Thank you for coming. In November of 2011, with the arrest of Jerry Sandusky, questions were asked by thousands of Pennsylvanians, the media, and people all across the country. And the question was, why did this take so long? I remember that I was woken up at midnight that night, and somebody sent me a text and said, turn on CNN. And I watched from midnight until 2 o'clock. And the first thing that I thought of was, what took so long? Why did this take so long? And the second thing I thought of was the kids who were involved and their parents. My sons were safely up in their beds asleep, and I knew that they were okay. And my heart broke for the kids who weren't okay, and my heart broke for the parents whose children were victimized by Jerry Sandusky. And then during the long campaign for Attorney General, everywhere I went, people were upset and bewildered. And they always came to me and said, why did this take so long? Why did these kids have to wait? It was a legitimate question, a very legitimate question. Some may say, well, what's the purpose of going back and looking? Sandusky was eventually convicted and is probably serving most of his life, if not the rest of his life, in jail. And the purpose is to make sure that the process protects children the best that it can do. We as prosecutors, and as you know, I was a child abuse prosecutor specialized in child sexual abuse in Lackawanna County. We as prosecutors need to do the best job. That's what we're paid to do. That's what the public relies upon us to do. That's what allows parents to put their heads on their pillows at night and know that somebody is taking care of their children. So all throughout the campaign, I heard from thousands and thousands of people. I promised Pennsylvania that I would look into what took so long, how this took so long, and why it took so long. I promised you that we would look at all of the facts. We would answer what we could, and where there was no direct evidence, we would tell you that as well. If there were conclusions to be drawn based upon the facts, we would draw those conclusions. If there were not conclusions that could be drawn, we would leave it into the hands of the public to make their own decisions. Once I took office, I moved to fulfill that promise by hiring Goeffrey Moulton. Some may say this review took longer than expected. That's correct. We did not want to leave any stone unturned, and we wanted to tell the whole story, the truth, the whole truth, and nothing but the truth. And during the course of the investigation, we learned that the email retention policy was changed and that millions of emails thought to have been deleted were now able to be recovered. We took the extra time to recover those emails and to look at the relevant emails, and they proved a vital part of this report. I hired Goeffrey Moulton to conduct a full, fair, factual, objective, and unbiased review of why this investigation took 32 months to come to an arrest. Goeffrey is an experienced, proven, accomplished prosecutor who was independent of this office and who did not have any reason or did not know any of the parties involved. This report that has been made available to you and is quite lengthy, I think you will see, is fair and comprehensive. The facts and the timeline are undisputed. Before we take questions, it's important for Goeffrey to go through all of the facts and the truth that is contained in this report. I appreciate the fact that the people of Pennsylvania are interested in how we can do things better. I appreciate the fact that we ask the tough questions that need to be asked and that we have someone like Goeffrey who searches for the truth. We want children in Pennsylvania and all across this country to be protected. And where this case can be one case study for prosecutors in making their decisions, it was worth all of the time and effort. And for the people of Pennsylvania to trust in their government and know that somebody is putting out the facts in a full and comprehensive and fair report, that's important to us as well. I will now introduce Special Deputy Attorney General Goeffrey Moulton.
Thank you, General. Again, thank you for giving me the opportunity to participate in what I think is a very important and worthwhile project. What I want to do now, and I hope you'll bear with me, is I'm going to walk fairly quickly through the report. It's pretty lengthy. There's a lot in there, and what I hope to do is for those of you in the room to give you a good sense of where you can find things so you can find them quickly and see what you're looking for. The report begins with an introduction. It runs from pages 1 through 30. The second half of that introduction, pages 12 through 30, is an overview of the entire report. So if you want to get a quick picture of the big picture, you can go there first. The introduction also describes the scope of the report, which is relatively narrow, and I will emphasize this now. It's relatively narrow compared to the wide range of issues that were raised by the Sandusky investigation and prosecution. My assignment, as Attorney General Kane mentioned, was first and foremost to find the facts and describe what happened during the course of the Sandusky investigation. After that, and that's the first part of the report addresses that. After that, my job was to address a series of questions, most of which centered on the question that the Attorney General mentioned, which is why the investigation took as long as it did. As Attorney General Kane told me when we first met about this and discussed this project, the ultimate goal was to see if there were lessons to be learned that it could improve the way that we serve and protect children in cases like this one. In terms of time, the report covers from November 2008, when victim 1 first described Sandusky's conduct to officials at his high school, through the end of 2011, which is when Sandusky was formally charged. So it does not cover the time period before victim 1's first allegation. It doesn't cover the trial and subsequent prosecutions either. Within that time period, November 2008 through the end of 2011, the report focuses mainly on the actions of law enforcement and child protective services. Everyone should understand that the report does not address a wide range of issues that fall outside of that scope, either in terms of time or subject matter, most notably issues concerned with the conduct of Penn State and their officials. The investigation also discusses methodology, including the recovery of deleted emails and witness interviews. On the interview front, by and large, we had very good cooperation. Almost everyone we asked agreed to participate, even though, because this was an administrative review, not a criminal investigation, we lacked subpoena power. The one notable exception was the decision of the Pennsylvania State Police not to make its members available for interviews. Their reasons for doing so are discussed in the introduction to the report. They're also discussed in a series of letters that we exchanged back and forth. And again, I'll let their description of why they chose to do that speak for itself. I'm happy to answer questions about that question or that issue, as well as the deleted emails issue when we get to questions and answers. The introduction also talks about the issue of what is sometimes called hindsight bias, right? The idea that it's much easier to connect the dots after the fact when you know the complete picture than it is beforehand. Are we being fair to the folks who are making decisions in this case, since we now know how things turned out? And of course, they couldn't have known that at the time that they were conducting the investigation. But the fact that hindsight is usually 20/20 does not mean, as some have suggested, that these after-the-fact appraisals are not worthwhile or not useful. To the contrary, successful organizations have long understood that learning from experience is one of the best ways to get better, and I think that's what we're trying to do here. Final part of the introduction I want to mention is on pages 11 and 12. It describes the procedural steps that we needed to take in order to release this report to the public. And those steps principally were two. They included getting the permission of the supervising grand jury judge, because this report talks about matters occurring before the grand jury. We don't have the authority to release it without the judge concluding that doing so is consistent with the interests protected by grand jury secrecy, so we did that. And in addition, we had to give notice. We gave notice to people who had a right to see the report under Pennsylvania law before it was released to the public. And that's why the report you have has a May 30th date on the front of it, but it's now June 23rd, and that's why we're releasing it to the public. Okay, on to the substance. Part one of the report reflects the first part of my assignment, and that is, it's a detailed description. It's the longest part of the report. It's a detailed description of what happened and what did not happen during the over 35 months between the beginning of the investigation in November 2008 and the filing of charges against Sandusky in November 2011. For organizational purposes, the report divides the investigation into 4 phases. And those are in a separate section in Part 1. Part 1, Section A, summarizes the first phase. which ran from the initial report by Victim 1 in 2008 until the referral of the case to the Office of Attorney General in March 2009. Again, that predated OAG's involvement in the case, but there are important lessons to be learned from that part of it. And again, the Attorney General made it clear to me when I started that she wanted me to start then, when Victim 1 made his first complaint. The second phase of the investigation is summarized in Part B, or Section B. It began in March 2009 when the Office of Attorney General got the case from the Center County District Attorney's Office, and ended in March 2010 when the assigned prosecutor, Janelle Eschbach, submitted a draft presentment to her supervisors suggesting that the case be charged then with a single victim. This phase, again discussed in Section B, includes the decision to submit the investigation to the grand jury. It includes a discussion of Victim 1's testimony before the grand jury. He actually testified twice during this phase. And it discusses early efforts to corroborate Victim 1. It also discusses investigative steps that were considered but not taken during this time, such as searching Sandusky's residence and going to the local Children and Youth Agency and asking whether there were other allegations against Sandusky. Those are things considered in 2009 but not undertaken. By the end of 2009, we get to the end of 2009, and the investigation has not identified any other victims. We just have Victim 1. And Eschbach, again, the assigned prosecutor, decided it was time to draft charges based on that one victim that they had. And she does that. In the third phase of the investigation, which is described in Section C of Part 1, it ran from March 2010, when Eschbach submitted her draft presentment to her supervisors, until the receipt of a tip about Mike McQueary, which came in November 2010. And Eschbach's draft presentment, if you're looking for it, is in Appendix F of the report. Now, this is a time period, again, this phase of the investigation, it's a time period when the recovery of email was particularly helpful in terms of understanding what happened. You'll see, as you look at the emails, that Eschbach sent a series of messages, a series of emails to her bosses, often after hearing from Victim 1's mother or psychologist, asking about or looking for an answer to whether or not she could charge the case based on that single victim. The answer she got, which was no, eventually came in August of 2012, 5 months after she first submitted her draft. And again, in the report, Appendix G contains a set of emails, which I think are interesting reading, that run from the submission of the draft presentment to the answer, no, we're not going to go forward now. Those are all contained in Appendix G. That decision, the decision in 2010 not to charge, based on the evidence available at the time, was made by then Attorney General Corbett. It was based on the collective advice of the people above Ms. Eschbach in the chain of command, all of whom apparently disagreed with her assessment. They all recommended to then Attorney General Corbett that the case not go forward at that time. Their view, as they explained it to me, and as they explained it at the time, was that Victim 1's testimony needed additional support in the form of other victims before the case could go forward. So what happened during that 5 months that the investigation, that the presentment was being considered? Well, unfortunately, during that time, the investigation was at a complete standstill. During those 5 months, March to August 2010, no witnesses were interviewed, no subpoenas were issued. And for the next 2+ months after that, no one new was interviewed, and the investigation did not succeed in identifying any new victims. So we get to the early November 2010, and as Eschbach put it when she was interviewed, the investigation was dead in the water at that time. Then on November 3rd, the Center County District Attorney, Stacey Parks Miller, received an email saying that investigators should talk to Mike McQueary, that he had information that was relevant to the investigation. And that email, which is in Appendix J, was the beginning of what the report describes as the fourth phase of the investigation. That phase ran from the McQueary tip, November 2011, through the filing of charges almost exactly 1 year later. So that McQueary tip, along with another important discovery that occurred right around the same time, which was the discovery of the 1998 allegations against Sandusky. Those two things together fundamentally changed the course of the investigation. From January 2011 through the filing of charges in November and December 2011, the investigation was now both wide-ranging and aggressive. Investigators and prosecutors conducted hundreds of interviews. They identified more Sandusky victims, and they investigated the conduct of Penn State administrators. The grand jury issued over 100 subpoenas during that time. It met on 18 separate occasions, as compared to just twice in 2010. And it heard the testimony of more than 50 witnesses, again, as compared to just two witnesses in 2010. This section of the report, rather than trying to cover in detail all of that activity, it's just not possible in a report of reasonable length to talk in detail about all the things that happened in 2011. What we did instead is summarize the most important activity during that time by month. So there's summaries by month. For more detail, you can look at the timeline at the end of the report, which details the investigative steps more fully. You'll see when you look at that timeline in Part 4 that in some single months in 2011, more investigative activity took place than in all of 2009 or in all of 2010. Part 1 ends by describing the run-up to the charging of Sandusky in November 2011 and then the filing of additional charges in December against him after more victims came forward at that time. All right, that brings us to Part 2, second major part of the report, and that begins on page 91. And what Part 2 does is it addresses the central issues raised by the events that occurred and did not occur in Part 1. And those issues are addressed in 7 sections. It's A through G. Most of those, but not all of them, most of them have to do with the question of why did it take as long as it did to bring charges. So Section A of Part 2 discusses the initial report by the Keystone Central School District to Clinton County CYS, which again occurred in November 2008, the day after Victim 1 first brought the allegations to the attention of folks at his school. And the focus in Section A is whether the district complied with its reporting obligations under Pennsylvania law. There's a lot of controversy about that, largely in the area of the school district, and so we wanted to address those questions. Here we worked with the Pennsylvania Department of Education that was conducting its own preliminary investigation based on media reports. We worked with them, and the bottom line is, despite important areas for improvement in the school district's handling of the matter, the report concludes, as did PDE, that the district and its officials substantially complied with their obligations under the law. Section B of Part 2 looks at the actions of Clinton County children and youth and law enforcement between the time of Victim 1's first report and the time the case got referred to the Office of Attorney General. And here, again, important lessons to be learned. So while Clinton County CYS treated Victim 1 with skill and care, there's no doubt about that, the level of coordination between CYS and its law enforcement partners was less than ideal. For example, despite the mandate of Pennsylvania's Child Protective Services law, no multidisciplinary investigative teams were convened by anyone involved. Neither district attorney nor anyone else convened an investigative team, even though that's what the law appears to mandate. Just as important, Sandusky was interviewed by CYS without the participation of a criminal investigator, without anybody from the district attorney's office, anybody from the Pennsylvania State Police. And that was a significant missed opportunity, because law enforcement never got a chance later to interview Sandusky. That was the one chance, and unfortunately, it didn't happen. Why does that matter? The folks at CYS did a commendable job in conducting the interview, but their focus is not on a later criminal investigation. Their focus is on child safety and deciding whether the report was indicated or not within the meaning of the law. Professional, trained investigators, had they participated, almost certainly would have gotten more valuable information out of Sandusky, either in the form of admissions or leads for other victims or additional information for a search warrant. Again, the interview went well, and it played an important role in the Sandusky trial, but had criminal investigators been involved, it would have likely been better. Again, the important thing, again, there's some dispute in the responses you'll see about who was responsible for that failure to have law enforcement participate. The bottom line, the important thing, though, is that interagency cooperation in this area has to be seamless, or it has to be seamless in these cases. And more specifically, when an alleged perpetrator is being interviewed, even if it's part of the child protective process, it's very important to get law enforcement involved at that time. Sticking with this phase, still, there was another crucial missed opportunity in 2009. As you all know, back in 1998, the Center County DA's office was involved in an investigation of Sandusky based on similar allegations. Obviously, new DA, new personnel there, but there was institutional knowledge within the Center County DA's office about that 1998 investigation. So we get to 2009, the case is being transferred from the Center County DA's office to the Office of Attorney General, and the fact that those 98 allegations existed was not passed on. Nobody at the Attorney General's office, nobody at Pennsylvania State Police was told about those earlier allegations. Why that did not happen is a great question, and it is not entirely clear. It was most likely, I think, an unfortunate failure of communication. There are different people with different recollections at the time. But again, the bottom line, investigators did not learn about those 98 allegations until more than a year and a half later. And had they known about them at the beginning, they certainly would have found other victims much more quickly than they did. Okay, moving forward to the time the case gets to the Office of Attorney General, the issue of the grand jury. Part 2, Section C addresses the use of the grand jury to investigate Sandusky. Both Eschbach and her supervisors, all the way up to the Attorney General at the time, they all believed that the advantages of the grand jury, mostly in terms of subpoena power, requirement of oath, secrecy of the investigation, that they all supported its use to investigate Sandusky. Of course, had the plan been to charge Sandusky right away, which other prosecutors might reasonably have pursued, right, there would have been little need for the grand jury. But that was not the plan. That was not the plan. The plan was not to charge right away. The plan was to investigate, and so the decision was made to use the grand jury. And so the report concludes that, again, while many prosecutors might have taken a different path here, they might have decided differently and quite reasonably, the decision to use a grand jury in this case was within the bounds of reasonable prosecutorial discretion. The report also concludes that given the decision not to charge right away, the use of the grand jury did not by itself appear to slow the investigation. Again, once the decision is made not to charge, we're going to investigate, did the grand jury slow the investigation? And sometimes grand juries do. They can be cumbersome. They only meet in Pennsylvania, they meet once a month for a week. It can be difficult to schedule witnesses. We looked here, and the reasons for delay here, on the list of reasons for delay, or the list of reasons for why the investigation took as long as it did, the use of the grand jury is not high on that list. Right? They didn't have trouble scheduling witnesses, et cetera. The real problem is really quite the opposite at some level, and that is for long stretches of time, before the investigation was ramped up in 2011, the resources of the grand jury were barely used at all. In 2010, for example, from the beginning of January through the end of October, okay, right before the McQueary tip, the grand jury issued no subpoenas for testimony, and it issued only one for records. In contrast, you look at 2011, for that same time period, January to October 2011, the grand jury issued more than 50 subpoenas for testimony and more than 50 subpoenas for records. Electoral politics. One of the big questions, obviously, that's been asked ever since Sandusky was first charged is whether Governor Corbett, while Attorney General, intentionally slowed the pace of the investigation for some electoral advantage. And in fact, a long period of delay in getting an answer in 2010, that March to August delay, led some people within the investigation to speculate that, or at least to ask that question. Led some people within the investigation to ask the question, was politics involved? It was, after all, an election year, and the Attorney General was running for governor. But despite that internal speculation, we looked very closely at everything that we could on this subject, talked to everybody we could on this subject. The report explains that we found no direct evidence that electoral politics influenced any important decision made in the investigation. And again, the report finds that we found no direct evidence that electoral politics influenced any important decision made in the investigation. In fact, there's nothing in the documentary record or witness interviews to suggest that then Attorney General Corbett gave any instructions at all about how to conduct the investigation of Sandusky. He did obviously make the decision not to charge in August, but other than that, at an operational level, he said and others said that he wasn't making those decisions. Those were all happening below him in the chain of command. Resources. Section E of the report discusses whether the assignment of additional resources earlier in the investigation would have resulted in the earlier filing of charges. And it's true, if you look at the timeline, you can't help but see this, right? It is true that in 2011 there was a significant increase both in investigative resources and in the pace and the scope of the investigation. But if you look at how most victims were identified, and the report does go through that in fair amount of detail, how was each victim identified in the investigation, you'll see that the identification of victims cannot be closely linked to a lack of resources or to the infusion of additional resources. And the best leads in late 2010 and early 2011, again, which led to the identification of 4 victims and 2 other incidents, they were entirely unrelated to new resources. Also, it appears that no investigative steps were considered and then skipped and delayed because of a lack of resources. Now, would more resources have helped? Sure, right? But only if they had been deployed to do the things that needed to be done. Should Sandusky have been charged earlier? Section F of the report takes on that question. And why are we asking that question? Why does that matter now that he's in prison for the rest of his life, or likely for the rest of his life? Well, timeliness is important in all criminal investigations, but it's especially important in child sexual abuse investigations. And why is that? That's because experience tells us, and the research tells us, that serial child molesters are significantly more likely than other offenders to continue their behavior, right? Even if they know that they're being investigated. So the comfort we might have in other investigations, well, we haven't charged yet, but the target knows we're investigating him, so he's unlikely to be continuing to offend. That does not necessarily apply when we're talking about these preferential serial child molesters. Now, before the Sandusky, obviously the case existed, the investigation existed for a period of time before it came to the Office of Attorney General. And before it came, and that was in March 2009, before that, neither the Clinton County District Attorney nor the Center County District Attorney had seriously considered filing charges. And that's because neither of them really considered the case on the merits before sending it on to its next stop. The Clinton County District Attorney had a familial conflict of interest. The Center County District Attorney had a familial conflict of interest, and that's why he sent the case to OAG. Before that, the Clinton County District Attorney saw the basic facts and saw that most of the conduct occurred in Center County, not Clinton County, and so he had sent it to the Center County District Attorney. What Section F of the report does is it focuses on the one point in the investigation when prosecutors did seriously consider bringing charges, and that was that March to August 2010 time period, when Eschbach submitted and her supervisors considered a draft presentment with victim 1 as the sole victim. Now, if you take as a given the state of evidence at the time, and that's a single victim with relatively modest corroboration, and a community icon as a possible defendant, again, taking the evidence as it was at the time, then the decision not to charge fit within acceptable bounds of prosecutorial discretion, even though other prosecutors, and most notably Janelle Eschbach, would have decided differently. But there's one major problem with that premise, that is taking the evidence as it existed at the time, and that's that had the investigators been more aggressive, and we'll talk about this in a couple minutes, had they taken the investigative steps that they could have taken in 2009 and in 2010 that they didn't take until 2011, they almost certainly would have had much more evidence by the summer of 2010, and so that decision would have been a lot easier. Right? As it was one about which reasonable minds differed because of the state of the evidence. But had they worked and done the things earlier in the investigation that they could and should have, in 2010 they would have had a much stronger case, a case that looked a lot more like the case they had in 2011. I want to mention one other point about that 2010 decision point. Senior leadership at the Office of Attorney General, they had a line prosecutor who wanted to file charges. Her bosses, though, up the chain of command, they all believed that the case was too weak to charge based on one victim, and they all believed that there were likely more victims out there. That was a premise from very early on, that this was not a single incident involving victim 1, but that Sandusky hadn't fit the profile of somebody who was likely to have offended on many occasions with many victims. So what happened in 2010, the decision, again, reasonable minds can differ about that decision whether to charge or not, but during the time that that they were considering the decision and for several months thereafter, there really was no concerted effort to go find more victims, and that's puzzling in retrospect. Okay, why did the Sandusky investigation take as long as it did? That's what the Attorney General said. That's the central question. All the questions sort of revolve around that question. And the final section of Part 2, which is Section G, addresses that overarching question. And if you're looking for a fairly quick synopsis of the answer, or really multiple answers to that question, you may want to start with Section G, which begins on page 122 of the report. Okay, given the decision at the beginning not to charge Sandusky based on victim 1 as the sole victim, questions about the investigation's length come down to why it took so long to find additional victims. That's the central question. And this report discusses several significant factors that contributed to that. Those include, first, miscommunication at the outset. We talked about that already. Second, the requirement under Pennsylvania law that child abuse allegations deemed unfounded must be expunged within a certain period of time. Now, that's apparently what happened with the 1998 allegations. Those allegations were referred to the Department of Public Welfare. They were considered by the district attorney at the time in Center County. The case was not charged at the time. Again, that's a subject beyond the scope of this report. But as a result of the case not being charged, then the record of those allegations had to be expunged from child line records. Right? And as a result, when the new allegations against Sandusky came in 2008 and 2009, a check of those records would have revealed no prior allegations. And so as a result of that, investigators, one of the reasons why investigators didn't learn about those 1990 allegations until later. And the third significant factor, sort of overarching factor as to why the investigation took as long as it did, was the failure to take certain steps earlier in the investigation that proved very valuable later on. Okay, what were those steps? The most significant of those steps, any one of which could have been taken in 2009 or 2010, were searching Sandusky's home, asking the local police about earlier investigations involving Sandusky. That's how they ended up getting the 1998 allegations or finding out about them, and questioning the local Children and Youth Service and the Second Mile about Sandusky as well. And again, the report talks about all those decisions. I want to spend a minute or two now, though, on the subject of the search, because this is really, I think, an area where there's an important lesson to be learned, I hope. As one expert put it in a book written before Sandusky was charged, I'm going to quote, "The major law enforcement problem with the use of search warrants in child sexual victimization cases is that they are not obtained soon enough." Again, that's not written about Sandusky. That's written generally about these sorts of cases. Read that again. "The major law enforcement problem with the use of search warrants in child sexual victimization cases is that they are not obtained soon enough." And that was certainly the case in the Sandusky investigation. The search of Sandusky's residence did not occur until June 2011. Right? That's more than 2 years after the case got to the Office of Attorney General, and as you'll see from the report, it's more than 18 months after searching was suggested by an investigator in the case. Again, more than 2 years after the case came in, more than 18 months after an investigator suggested conducting the search. And when the search finally did happen, it uncovered unquestionably valuable evidence, including photographs of Sandusky victims and lists of Second Mile campers with asterisks next to some of their names, asterisks that later turned out to line up with people that Sandusky had victimized. Had the search been conducted in 2009 or 2010, investigators could have used those photographs and could have used the names to find victims much earlier than they did. Now, why did the search not happen earlier? There are a number of reasons given, one of which was to keep the investigation secret. Another was a concern about the lack of probable cause or staleness. But the experts tell us that serial child molesters regularly maintain, in terms of staleness, which is the idea that months after a crime has occurred, it may be less likely that evidence of that crime is going to still exist at the location in question. So was it likely? And victim one's, I knew I was going to do that. Victim one's allegations were about conduct that ended in the fall of 2008. Right? The case doesn't come to the Office of Attorney General until March of 2009. So a number of months have passed. Is it now too late to conduct a search? Is the evidence stale? And the answer to that is no. The simple answer to that is no. And in fact, the evidence was not much fresher in 2011 than it was back in 2009. And that's because experts tell us that serial child molesters regularly maintain valuable evidence about their crimes, including items as simple as ordinary photographs of their victims, which is something that Sandusky did. Moreover, Victim 1 described being abused in Sandusky's basement at his home and provided investigators with valuable and significant details about the layout of the home. If for no other reason, a search early on could have provided very useful corroboration for Victim 1's story, which is exactly what some people were saying they needed before they could charge, and yet the search didn't happen. Based on some of the responses to this report, some of the people involved apparently still think that they did not have probable cause back in 2009 or that the evidence was too stale. I completely disagree with that. Search warrants are properly issued every day based on the word of a single victim. If the idea that a single victim wasn't enough to get probable cause, that would be astonishing. Right? It's one thing to say that a single victim might not be enough to support a conviction. Right? Again, we talked about that. That's something that reasonable minds might differ about. But it is quite another thing, and I think quite wrong, to suggest that it's not enough for a search. Again, as for staleness, this issue of staleness was the information too old to justify a search? Well, it was too old in 2009. It would have been too old in 2011. Right? There's nothing in the search warrant affidavit, which is in the report as well. I don't remember the appendix number, but it's in the report. There's nothing in there about any victim victimized after Victim 1. There's no fresh information in that. But that doesn't matter. The search warrant was properly issued. Right? It was properly issued and not really vigorously challenged by Sandusky. And why is that? And that's because of the well-documented desire of multi-victim child molesters to hang on to evidence of their crimes, even when they're aware that an investigation is ongoing. And again, that fact can be used and should be used to defeat claims that a warrant was stale. Right? Again, this is an important lesson for anyone who works in this field. Search. I mean, there may be reasons not to search. Maybe you don't want to tip off the target that he's a target of investigation, but Sandusky had known for quite some time, by the time the case got to the Office of Attorney General, that he was a target, and yet the search didn't happen. Okay, now speaking of lessons, it's time for me to get close to stop talking. Speaking of lessons, Part 3, which begins on page 132, makes a series of recommendations to the Office of Attorney General based on the body of the report. Part 4, I already mentioned, is a timeline. It starts on page 142, and it consists of a detailed list of investigative steps and other significant events in the Sandusky investigation. And then I mentioned earlier, the back of the report, you see the last tab in the report is a tab marked responses. And those are responses from people who had the opportunity to view the report before it was published. I want to make clear that while we have provided those individuals with the opportunity to respond, and we've attached their responses out of fairness and out of convenience as well for everybody else, the views expressed in each response are those of the author of that response. The fact that they're appended to the report does not mean they're views that I agree with or the Office of Attorney General agrees with. Now, again, some changes were made to the report based on those responses. They are all marked clearly in the report. You'll see asterisk footnotes that mark where changes got made as a result of the responses. Okay. Before we get to your questions, I want to emphasize at the end here why I believe that this project was worthwhile. There are critics who say and have said that you shouldn't conduct a post-event review like this, or at least not publicly conduct one, when the underlying event was successful. And here there's no doubt that the final result, the final outcome was a success. Sandusky will almost certainly spend the rest of his life in prison. And I want to make sure we say that many people worked long and hard to produce that result, right? And many victims showed great courage in testifying and telling their stories. Those people all deserve both our admiration and our thanks. But even a highly successful final result does not mean that the investigation itself was a complete success, particularly when a serial child molester was left uncharged for so long. There are plenty of lessons to be learned from this investigation, from this prosecution, lessons that will help law enforcement, that will help Child Protective Services, and it will even help members of the public understand better and do better in the future. I'd like to again thank Attorney General Kane for giving me the opportunity to participate in this project and for providing me with the resources at OAG that I needed to complete it, particularly Laura Ditka and Dave Pfeiffer, who brought not only tremendous energy but also vast experience in this area to the table. And I also want to mention Braden Cook, who is a true computer forensic genius, and he was the one who enabled us to recover these emails, which I think are pretty important to telling the story. So that's all I have to say right now. I think we're going to open the floor for questions. Yeah.
As a candidate, you said that you thought the delay that has now been documented was probably due to politics. Even though the report found no evidence of that, do you still believe that?
This report was a very fair and factual report, and as I said from the very beginning, we will leave no stone unturned, and I believe that's exactly what this report does. And I also said, where there is direct evidence, we will give it to you, whether it means that somebody did something or someone did not do something. That's exactly what this report accomplishes. This report found no direct evidence, no email, no confession, no statement from anybody indicating that they were told to slow this down because of politics. This report also shows long periods of inexcusable, and by inexcusable I mean that even the parties involved couldn't offer an excuse for the delays, and delays that quite honestly are unfathomable to most of us. Why those delays took place, we don't know the answer to that. We don't know what was in their head. They describe it as there was also tactical errors that were made that could have moved this case 2 years sooner, at least 2 years sooner than it was. And those are inexplainable. So where we have no direct evidence that politics played a part, we are giving you those factual basis. Where there is evidence that it just took too long, and why it took too long because of the delays. For example, the 5-month delay between March of 2010 until November of 2010 as to why the presentment sat on someone's desk and there was no answer given. We don't know why that happened.
But the question was, do you still believe it was politics?
I've always said from the very beginning, and I am a prosecutor through and through, and in a closing argument, it doesn't matter what our personal opinion is. I rely upon the facts, and the facts is there was no direct evidence, but there are questions of inexcusable delays. Why those delays took place, we don't know. There are questions of tactical errors that were made. Why were those tactical errors made? We don't know. And in that instance, we have to put it out to the public, and just like a jury, we have to say, you need to base your opinion upon the facts, and you need to rely upon your own personal experiences.
Does Governor Corbett deserve a public apology and his people, since it was found that this was not politically motivated?
What this report found is that there was no direct evidence that it was politically motivated. Like I said, we went through Jeff went through thousands and thousands and thousands of emails. The relevant portions are attached in the report. There was no confession and there was no statement. There are serious questions as to why those delays occurred. Why was there inactivity or virtual inactivity for almost 18 months? Why wasn't a search warrant issued in the beginning? Why did it sit on someone's desk? And for that, we can't answer.
Were they reckless, and should they have been made in the first place?
I'm sorry, can you state your question again?
That this was politically motivated somehow, the reason for the delay in the investigation. You made those statements. Should there be an apology, and were those reckless?
I said from the beginning that we need to ask the questions, and I don't think anybody should ever apologize for asking tough questions. We asked the questions. I promised a full, fair, comprehensive, and factual report, and that's exactly what we're giving you today.
Are you concerned about a potentially chilling effect at all on prosecutors who might be working on a potentially high-profile case in the future? Are you concerned about the possibility that they may think they have to press charges before a case might be ready because they're afraid of being the subject of another report in the future?
I was that prosecutor. I was the prosecutor who investigated and also brought to trial many child abuse cases, child sexual abuse cases. And I don't believe that any prosecutor whose main goal is to take a violent criminal off of the street while building a good case, I don't believe that their goal would ever be chilled by a case study and how we could do it better. If anything, this is an addition to the knowledge that they have, it's an addition to the training that they have, and it should never be a chilling effect. I think for the most part, they will be happy that we have looked at this case and we've looked at how to do it better and how to make children safer.
This report details missteps, miscommunication, missed opportunities. Who should be held accountable for that?
That's a good question. it appears as that the line prosecutor from the very beginning wanted, and as well as the agent and the troopers, wanted to conduct a search warrant, which was never done. It was declined, that it was rejected that they would be able to do a search warrant. It was the decision of the group to use a grand jury, and that's prosecutorial discretion. Some people would go that route. Some people wouldn't. But once you go that route, you have to use the tools of the grand jury that were offered. And as the report indicates, through long periods of 2009 and 2010, the grand jury resources were not used fully, as opposed to what happened in 2011. So it appears that the leadership of OAG, who was making the decisions, not the line prosecutor, had a real lack of urgency in taking Sandusky off of the streets, and also made some tactical errors that could have brought him off of the streets sooner.
You say the leadership, do you mean Tom Corbett?
Well, the leadership consisted of the chief of the criminal unit at the time, the chief of the criminal division at the time, the first deputy at the time, and the attorney general at the time.
General, you say, and you've said several times today, that there were crucial missteps, that there were inexplicable delays. I guess what I'm trying to understand is, are you saying that these occurred because of incompetence, and are you also, what were, if any, the negative impacts from this? Because it doesn't seem that the report points out any negative impacts about delays or lulls in the investigation, which you pointed out today.
Well, in terms of again, what I mentioned earlier, just to take first shot at answering the question, timeliness is important in these cases, right? It's important to consider, and the general has made this point, important to consider why things took as long as they did. In terms of consequences, the longer somebody like Jerry Sandusky is out and about, unouted to the public, the more risk he poses to the community. Was the case in 2011, when it was charged and tried in 2012, a rock-solid case against him? Sure. There were a lot, and would it have been a tougher thing to do to charge him earlier if they didn't have any additional evidence? Yes, it would have. But that doesn't mean the right answer is to wait until the case is as strong as possible. So really, we're looking at the question going forward: how should investigators and prosecutors address these sorts of cases in the future?
That there were delays. I mean, are you saying that these prosecutors were not competent in doing this investigation, or what are you saying exactly?
I think, and I'm not going to talk about competence. What happened is things that should have happened. There are two sets of problems, right? There are investigative steps that were not taken until 2011 that could have been taken in 2009, and I think for some of those steps, maybe there was a rationale for that. I mean, one of the rationales offered was, well, we didn't want to go to Penn State or to the local police department or Center County CYS, because if we did, then Penn State would find out about the investigation, and that might be bad. But on the other hand, there were decisions that were made that I think reasonable minds shouldn't differ about, like, for example, searching Sandusky's house. That could have happened in 2009, should have happened in 2009. So there are those sorts of decisions. There are also delays. Again, that March to August 2010 time period, not only was it a long time coming, the answer, but during that time, nobody was doing any investigation. Now, were they not doing anything? No, everybody was busy. The office, had a high workload. People were working on other cases, but they weren't pursuing this.
That in any type of long-term investigation, and can you sit here today and say definitively this was a good investigation or it was a bad investigation?
I was not asked to look at the question whether it was good or it was bad. What I was asked to do was to first find the facts. Why did it take as long as it did? And the report describes that. And then second, to see if there are ways in which we can help all of us learn better about how to handle these cases going forward. Good or bad is, that's people can read the report and make their own judgment. The final outcome was quite good. There's no doubt about that. In terms of the progress of the investigation, I think there are a lot of ways in which it could have been improved.
In the course of your investigation, did you become aware of any new victims who were alleging sexual abuse by Jerry Sandusky that happened after the case was transferred to the Office of Attorney General?
I think that was outside the scope of my responsibilities. My responsibilities were to look at what happened through charging in November 2011. I think there's an answer to that question from the office.
I'll take that. Yes, we do have two individuals who indicated that they were abused by Sandusky both in the fall of 2009.
Brad? Well, could you elaborate on that? I mean, what happened? Did you investigate those cases then?
Those cases were already known before I took office.
Well, the follow-up question I have is sort of on
Are they new victims? Yeah. Are they? Did he reoffend while the investigation was going on? Is that what you've now said?
The Office of Attorney General received the case in March of 2009, and 2 individuals indicated that they were abused by Sandusky sexually in the fall of 2009.
That figured in the prosecution?
They're not.
Well, are they going to be charges related to those two, or where do those cases stand?
Besides, as you all know, and as you also have the respect for the victims of child sexual abuse that we do, we don't want to give any identifying information for these individuals. Because Sandusky is in jail, there were also victims that we found that were not found previously, and those victims have indicated that because he is in jail and the appeal went well for the Office of Attorney General, they do not wish to prosecute at this time.
How many of those victims are there out there? So you said 2, and then you just mentioned that there are even others. There are more.
Yes, but let's keep it straight. There's 2 separate questions here. There is a question as to whether anybody indicated that they were abused by Sandusky after the Office of Attorney General received the referral in March of 2009 and while Sandusky was walking the streets. The answer to that question is 2 individuals have indicated that they were abused by Sandusky in the fall of 2009. Your other question is, well, besides the victims that are already known and prosecuted, did Sandusky victimize even more, whether that was even in the 1990s? And the answer to that question is yes. But the victims that we know about as far as the fall of 2009, that's as far as we know.
2009, were they part of the civil litigation that you're aware of? Did they get remuneration of any sort?
Brad, I can't give you any more identifiable information about the victims.
A lot of the 5-month time lapse, the exchanges are captured in emails. Janelle Eschbach provide any more details about that conversations or any other attempts to move the case forward?
Yeah, I think that everything that I thought was significant and relevant is contained in the report. So you've got the emails. We obviously interviewed Ms. Eschbach at great length. And so, by and large, you can see from the report what she said. I mean, for the most part, what we have is a series of emails from her, first to her immediate supervisors, and then up the chain beyond that, asking when she was going to get an answer. And by and large, as she described it, those were chiefly her communications with those folks in terms of asking what was going on and when she was going to get an answer. And again, you've got all those emails in I think it's behind tab G.
Yes, about the 2 victims that indicated they were abused in fall of 2009. I just wanted to ask you, so was there any investigation done as to the credibility of those persons' allegations, and do you believe they're founded? Do you believe they were credible to the point where law enforcement could have pursued them? Because the reason I ask that is I remember that there was one story about somebody that came forward and it was indicated that it may not have been founded. And so can you tell me what your thoughts are about the credibility of those 2 allegations?
I'm not going to discuss the credibility of sexual abuse victims until they are found by a jury to be uncredible or incredible. The victims of sexual assault, when they tell us they're the victims of sexual assault, and unless we have anything to the contrary, we believe them.
Did anybody look at their cases? Did anybody attempt to prosecute them or take those basic steps to start to prosecute them? Because you said it was the prior team knew about
That's
them.
correct. They were known by the prior team. We found out about them when I came into office, and any other identifiable information, whether they were the part of a civil suit, whether the prior team made any decisions as to their credibility, I'm not going to discuss.
Mr. Moulton, can you elaborate on state police's role in your investigation, when they cooperated, didn't cooperate?
So obviously, this was an investigation that began before it got to the Office of Attorney General. It began with a referral to the Pennsylvania State Police in November 2008 by the Clinton County Children and Youth Services. So there were, from the beginning, there was a state trooper assigned and a supervisor assigned. And then when we get to 2011, a bunch more folks from PSP were assigned. Very early on, I wanted to interview those folks. And I thought that was going to happen. I had a number of conversations with PSP's chief counsel, some of which were reduced to letters back and forth. Those letters are all in Appendix H of the report. In the end, they decided, to my disappointment, in the end they decided that they were not going to make their members available. Colonel Noonan, they did make available. I interviewed Colonel Noonan. His involvement in this case was mostly when he was at the Office of Attorney General, although obviously he became the commissioner and had a role over there as well. But in terms of the investigators, they did not make them available. They gave their reasons. Their principal reason is that they were concerned it was going to have might have an adverse effect on the pending trial, the still pending trial of against Spanier, Curley, and Schultz. You can see from the report that I disagree with that assessment. The folks at the Office of Attorney General who are prosecuting the case also disagree with that assessment. But again, I respect their decision. They made that decision, and it left us with some holes for sure. Having said that, thankfully, other investigators participated. PSP is pretty meticulous in preparing reports of the things they do, so we had their report, and we got to look at all that. So it was a problem, not an insurmountable one, and it was a disappointment. I did try later in the game, as late as May of this year, to ask them to reconsider their decision, and they stuck with it.
Hi, Mr. Moulton. As someone intimately familiar with the investigation as it played out, starting actually the timeline begins in the fall of 2008, is it conceivable to you that if the investigation had been executed at whatever level in a different way, that the two victims who say that they were abused or assaulted, in the fall of 2009, that either or both of those might not have happened?
Well, I think that lots of choices got made here. One of the choices that got made really both by the two district attorneys who had the case briefly and by the Office of Attorney General right at the beginning in March 2009, the choice was made that we're going to investigate further before we bring charges. Had that decision not been made, had he been charged right at the outset, then I don't know. I mean, if he'd been charged right at the outset, then there would have been a greater level of public awareness that he was a child molester. Now, he was released on bail, as it turned out, in 2010. But sure, if the case had been charged sooner, it could have been charged. Could it have been charged before 2009? Yes, people could have made the decision to charge right away.
Did you find evidence that there was a discussion, that was a part of discussion, that people were saying, well, if there's evidence of this before and he's still at large, there might be the better part of that. The merit might be in just charging now. And
well, I think there's the people who were involved in the investigation, the investigators who spoke to us, and the prosecutors, all of whom spoke to us, were aware of the risk. Right? They were aware that he might be continuing to offend, and they hoped that the fact that he was aware of the investigation would make that less likely. And they concluded that the risk of a failed prosecution was greater than the risk posed by that. So they did have those discussions.
The Attorney General, could you ask, could the Attorney General answer that question, though? I mean, I know he's directed it to Mr. Moulton, but, I mean, isn't that a crucial question? Madam Attorney General, do you believe those victims who come forward in the fall of 2009 would not have been abused had this investigation gone more quickly?
If different steps were taken, if the course of action was taken that the search warrant would have been issued and executed, which could have been executed under seal right away, based upon the statements of victim one, then they would have found the corroborating evidence that they felt necessary for victim one. They also would have found the additional victims that they also felt necessary, would have made the case stronger. If that had happened, then Sandusky would have been charged earlier, no doubt. Now, prosecutors you're going to have prosecutors coming out of the woodwork saying, well, we feel that the grand jury was the better choice. Okay, if you make that choice that the grand jury is the better choice and you go that route, then use the tools of the grand jury. You have to use all of the tools necessary, because there's a real difference between making sure that the streets are safe from a sexual offender and building a winnable case. You have to make that decision. Different prosecutors make different decisions. I would have made a different decision.
And so the two people who come forward in the fall would not have been abused had they made the decision that you're now advocating.
Logically speaking, if different tactics were taken and a different route was chosen, and Sandusky was in jail with bail, by the way, if bail hadn't been that he was released on, with a cash amount, if he was in jail, of course, there wouldn't be more victims, of course.
Saying that Tom Corbett mishandled the investigation and prosecution.
I am not saying that. I am saying that we have a factual report in front of us. This factual report indicates that there are long periods of time where nothing happened. There are long periods of delays that we can't explain. This report also indicates factually that key investigative steps were not taken early on. For example, the search warrant. And because of that, the case took longer than it could have or should have. What this report also indicates, this factual, unbiased report indicates that the reasons put forth, Mr. Moulton's reasons put forth of, well, why did they take these certain tactics? Why did they use the grand jury? Why did they not issue the search warrant? Indicates that there wasn't that sense of urgency to get Sandusky off of the streets that other prosecutors may have had, and therefore chosen different courses of action.
Two more questions.
Sorry, I can't hear
you. We'll be available all day. All
stop with the Attorney General.
Listen, I can tell you what my leadership style is, and then it's going to be up to the public to decide. Different prosecutors have prosecutorial discretion. They do. That's the way it's got to be. Prosecutors are highly trained. I can tell you that I would not have done that differently, but that's my opinion. Jeff's factual report indicates that there were long periods of delays and there were investigative steps that weren't taken that could have given not only a different result, but could have done it in less period of time. I would have done it. I would have issued a search warrant. Whether that's, hold on one second. So the question was, does the buck stop with the Attorney General? The buck always stops with the leader. But in this case, don't forget, there was no direct evidence. There was no email. There was no confession. There was no statement that indicated that the Attorney General at the time did it for political reasons. What it appeared to be is that there was a lack of urgency on the part of leadership. Why? We don't know that. That's going to be up to the public to decide.
Steve, hold on. Steve, I got a question.
Why were so many troopers transferred off the case? Is that normal procedure, and is it normal procedure for the next trooper to re-interview the victims?
I think that's a better question for Mr. Moulton, since he went through the transfer of the troopers.
Yeah, there were several. You're right. At the beginning of this investigation, there were several troopers assigned as the initial, as the lead investigator. First one, Trooper Kavanaugh, was involved for several months. It was then transferred to another trooper, and then by May 2009, Trooper Scott Rossman was assigned, and he was involved in the case through most of the rest of the investigation. In terms of why that happened, that unfortunately is something. The transfers are something that I don't have the answer to because I couldn't interview those folks.
Victims in the report. Yeah. Why isn't it in the report? If it is that significant, and although I'm confused about what you're saying about the timeline, are you saying prosecutors at the time knew about these victims, didn't investigate them, didn't look into? Why isn't that in the report? If that's what you're saying here?
I'm assuming that question is directed to me, or would you rather Mr. Moulton?
So let me just take on the factual side of things. First, the Office of Attorney General is entirely separate from my project. Was, as the Attorney General has said, was looking at the question of were there additional victims, should there be additional charges be brought, et cetera. With respect to the victims that she's mentioned, the people who allege that they were victimized in the fall of 2009, I think my understanding of the facts is that those are folks who, during the course of the investigation, and I think not before 2011, investigators learned about. So I don't think there's no suggestion that folks knew in the fall of 2009 that these additional victims existed. They believed there were additional victims, but they didn't come to light until 2011. The investigation, as far as I'm aware, the investigation was not aware of any additional victim besides victim 1 until the Mike McQuarrie. That was the first one.
Mr. Moulton, General Kane, you painted a fairly specific picture of then Attorney General Corbett's involvement here, saying he never made any substantial decisions on the conduct of the investigation.
John, can you speak?
I'm sorry, you painted a fairly specific picture, saying that then Attorney General Corbett never made any substantive decisions related to the conduct of this investigation. Is that standard? Is that a standard way for an incumbent Attorney General to operate, or does that paint a picture of him as a disengaged manager from the affairs of his office?
First of all, the statement, your statement of the involvement of then Attorney General comes directly from this report. So just so that we're clear on that. And you're asking me what my personal opinion of how an Attorney General should operate is. And, you know, you're going to get at least 50 different opinions on how Attorney General should operate. And that's not up to me to decide. I can tell you how I operate. I can tell you, you know, how I go about things, but that doesn't necessarily mean that someone else does it the wrong way. That's up to the public to decide. The public chooses their leaders. It's up to you to decide what style of leadership you believe is best serves the public.
All right, we can take your questions afterwards. You have our contact information at the bottom of the release. Then we're going to wrap up for now. We're getting a little repetitive. So.
Well, I have one. Could I just ask you, you talked about people within the investigation who speculated that politics were involved. I haven't come across any names or references to agencies that they were involved with. Did that come from the state police or agency?
All of the information that I think is appropriate for me to provide about that is in the report.
We'll follow up.
Thank you. I would love to sit here all day and answer your questions, but I will tell you that I have another pressing matter that deals with the welfare of thousands of Pennsylvanians. We have quite a bit going on, but however, I will recommend that you do read the entire report. The reason that we didn't come out in the beginning and put out dribs and drabs is because you need a comprehensive report. So I encourage you and the public to read the entire report. As JJ has indicated, we're not going anywhere. We will be available for your questions, and we'd like to answer as many as we possibly can. Thank you. Thank you.